There's one journalist in New York who's fighting for free speech for America, and you know him. His name is Good Logic. He's on YouTube, he's on Rumble, and he's on Locals, and we're going to read through a filing that he was brave enough to submit with courage to go into the lion's den, of course, New York, where Donald Trump is on trial in the Bragg prosecution, where the key witnesses are Stormy Daniels and Michael Cohen, and Trump has been gagged, right? He's running for president, 2024 leading contender. We'd all like to hear from him to see what he has to say about the justice system, given the fact that the justice system is kind of an important issue in America, but he's not allowed to talk about it because we have a problematic relationship with the judge and the daughter that is really bad for the judge to hear us all talk about, and so Trump is gagged. Nothing can come out unless Joe Neerman, Good Logic, has something to say about it. This is what is now being filed in the Trump prosecution challenging Mercan's gag of Trump. Good Logic, Joe Neerman, writes the following. All right, courts in New York, appellate court, here's my verified petition. Of course, the case is Good Logic and Joe Neerman versus Juan Mercan, the gagger. He says, okay, Joe Neerman, Good Logic is here. I'm writing this, and the reason we're doing this is because I want this court to do the following. First and foremost, overturn Judge Mercan's gag order that was entered against Donald Trump referenced in the indictment. And number two, overturn the clarification, an additional order that gagged Trump even harder. And number three, obtain a temporary restraining order that stays this gag and allows Trump to speak, and also enjoin any other orders as this case proceeds and any other relief that you have deemed appropriate. Now, Joe says, I am a party to this lawsuit, and this is important. He says, I'm not just a regular citizen. First of all, I'm a resident of New Jersey, but I'm an attorney and I'm licensed to practice law there in New York. I do business there. I've got my law license from you, where this case is. And additionally to that, I am also a reporter, says Joe, licensed to operate in the city of New York. And Joe has press credentials that were issued by the city of New York to say, hello, I'm a reporter. I need to report on the news. So Good Logic, he's formed in New Jersey. He's the exclusive owner. And the purpose of this is to create brilliant political and legal analysis, which he does well. He says, upon information and belief, Mercan is a judge. We know the story with him. So here's the background. Our friend Good Logic, who's on YouTube, Rumble, and next door on Local, says, across a multitude of social media platforms, petitioners, Good Logic, provide legal information, philosophical discussion, and entertaining, that's for sure, commentary regarding law, politics, and current events. He says Good Logic controls two channels on YouTube. One's called Good Logic, and the other one is called The Trump Trial. Now, additionally, he also controls channels on Rumble and other sites, has over 100,000 subscribers collectively, and he also promotes on X, where he's got 40,000 followers. And the point of this, right, is to tell us there's a lot of people who want to hear this. A lot of people interested in this stuff and in these stories, and it's a critical issue in our election, right? The First Amendment is not only about the right to speak. We can all just blab our mouths. But if nobody can listen to you because you can criminalize the listening or prevent the listening by criminalizing the speaker, right, that is impinging upon our right to hear. Joe says, petitioners live stream to Good Logic channels 5 or 6 nights a week, because he's a workhorse, man, and he averages over 2 hours per episodes. The live streams focus on legal and political news, usually get over 10,000 views, as many as 50. Now, Joe's audience comes from both sides of the political aisle, because he's a free-thinking man. Petitioners work to enlighten their audience about strengths and weaknesses of opposing claims and philosophies and legal arguments, and to consider alternative viewpoints. And the popularity of Joe's channels arise from a focus of avoiding being a homer for a political viewpoint and encouraging the audience to, think for yourselves without hesitating to question viewpoints promoted by anybody, even petitioners themselves. He says, question Joe. He's all for it. Let's talk. Now, the civil and criminal actions against President Trump are a frequent topic on Joe's channels. People from both sides of the aisle crave information about this case. And he says, by the way, Trump is not merely the 45th president of the United States. He's also the presumptive nominee for 2024. And it's indisputable that Trump's thoughts, ideas, and words carry great significance to millions of Americans, whether they love him, loathe him, or whether they fall somewhere in between. Now, the U.S. Supreme Court has made clear that Joe's audience, like all Americans, have the right to hear from Trump's own mouth his thoughts about political corruption and the potential weaponization of our courts and our prosecutors, saying, in a quote, this right to listen to Trump has its fullest and most urgent application at a campaign for political office. Now, Mercan's gag order unconstitutionally infringes upon upon Trump's freedom of speech. That's true. But it's beyond that, okay? It carries over to an infringement on Joe's right to freedom of the press. And Joe, as a member of the press who's duly licensed in New York, has a fundamental First Amendment right too, to receive and to report about this, about his involvement in the justice system. And Merchan is illegally restraining Trump from speaking about the case. And what does that do? Oh yeah, it causes irreparable harm not only to Good Logic, but guess what, America? To the audience of the amazing Good Logic channels and to its viewers and to us, the American people. So Joe continues to write brilliantly. Let's talk about this. He says, first of all, members of the media have the right to challenge gag orders, right? New York Times, we could do this. They wrote in New York Times, others brought an original action to the appellate court pursuant to Article 78, just like Joe's doing here, to prohibit enforcement of an oral ruling in a criminal action that directed all the attorneys to stop talking to the media. The court said the restrictive order in question is constitutionally impermissible, so the gag is not allowed. Imposition of a gag order is constitutionally impermissible. Great citation. He says similarly, in NBC, this case from 1986, the court there explained that NBC clearly has standing to question the directive that challenges the ability to speak with the media. You can't gag there either. And so based on the foregoing, we have the right to challenge. We have the standing to be here. We can bring this claim. Other people have done it, and we're here doing it too. Now, here's the problem. Here's the proceeding that was bad. Joe says, on or about March 30th, Bragg got an indictment against Trump. Case went over to Merchan, was assigned over there for some reason. Now, Trump was arraigned on April 4th, and news reports indicated that there was a discussion of the gag order at the arraignment itself. During that hearing, at the very beginning of the case, Merchan came out and he said, you know, gag orders like restraints are the most serious and the least intolerable on First Amendment rights. And that applies doubly to Mr. Trump because he's a candidate for presidency. It's like, oh yeah, that's a good point. Thanks for reminding the judge. Upon information and belief, Joe says, the court issued no order restraining Trump's speech at his arraignment, but then he made a request on the issue. CNN said, please refrain from making comments that are engaging or doing conduct that's likely to incite violence, create civil unrest, or jeopardize America. Okay, we're familiar with all that. Joe says, now this indictment was the first time in American history that a former president was indicted by grand jury. Bragg was first. It was the first of the 4 indictments that Trump would have to face. In addition, Trump was also indicted in Florida and DC and Big Fanny Land. Additionally, he spent last year defending multiple claims, E. Jean Carroll and Tishy. And finally, he had to fight off getting removed from the ballot. SCOTUS blew them out of the water. Remember Judge Lawgic? Undeniable, irrefutable, unequivocal. Sorry, Judge, 9-0. Upon information and belief, Trump reacted similarly to each challenge. Trump said, I'm being prosecuted, persecuted. I'm a victim of a witch hunt. Routinely mocked, questioned the competence of other people, judges, prosecutors, witnesses. And so these are generally referred to as Trump statements. Now, despite the similarity of his statements, Trump has a right to free speech, and the public has a right to freedom of the press. Now, in most scenarios, the court and even prosecutors recognize the sanguinity of Judge Merchan's initial take, right? He said, you're running for president. Now, while the indictment was issued in March 2023, Bragg waited nearly a full year until Feb 26 to then try to gag Trump. At the time the subject motion was filed, Bragg's trial was set to commence on the 25th. So he filed it like a month before, less than 1 month. With international media attention now ramping up, Trump's now the major candidate. The timing of the motion was as damaging as possible to Trump and to allow little opportunity for appellate oversight. Great point. The whole case has really been like this, where they're just delaying. Pre-indictment delay, right? Delay, then go at the last minute. Trial happens. You have no time to appeal. They dump all the discovery within the last month or 100,000 pages of it, and Trump can't get it together in time by design. Now, significantly, no claim was ever made by the movements that a single one of Trump's statements ever broke federal law. No charges have ever been brought. Now, there was an order from Trump, which we've read here many times. He can't talk about the family members of people who are related to the case, but it did not purport to govern Trump's statements about Merchan. Now, shortly after the order was issued, Trump came out on Truth Social. Trump wrote this on Truth. He said, back on March 28th, he said, Judge Juan Merchan is totally compromised and should be removed from this Trump case immediately. His daughter, Lauren, is a rabid Trump hater who has admitted to having conversations with her father about me that we played in our first segment, and yet he gagged me. Now, she works for crooked Joe Biden, Kamala Harris, Adam Shifty Shift, and other radical leftists who campaign on getting Trump, and they fundraise off the Biden indictments, including this witch hunt, which her father presides over, a total conflict and attacking Biden's political opponents through the court. Former DA Cy Vance refused to bring this case, as did all federal agencies, including elections. Joe says, now the subject social media post caused them to expand the order. Then they came back in and they expanded to the family members of the court and the DA. Originally, it wasn't all of them, but now they expanded it. And Trump got a warning saying, if you violate this order, you're in big trouble. So the background is now complete. And now Joe's going to take us through some arguments, and he's got several. He writes, all right, there are several fatal flaws with your gags, Trump judge. Now, any of these flaws warrant a grant of this petition. Here are the three that we're going to dig into. One, there was a flawed analysis of case law by Merchan, and also a flawed application of case law and defendants' fundamental rights to a fair trial. Flawed analysis of case law, a flawed application of the case law, and an interference with Trump's fundamental right to a fair trial. He says, all right, let's be clear about what happened with Judge Wan. He says the court's analysis from Merchan stands in a 180-degree opposition to the very cases that the court used to justify its decision. In other words, the judge relied on cases that say the opposite. He says they say something, but it's literally the opposite. He wrote, the freedom of speech is guaranteed by the First Amendment and the state's interest in the fair administration of justice. See that? State's interest. Does the state have an interest? Now, the court cited Landmark and Shepard, two important cases. And he said, well, Merchan, we have this balancing test and we'll be able to use this to decide. Now, Good Logic says, no, not so fast, Judge Merchan. Silly. He says, I respectfully submit that it was material error for Judge Merchan to conclude that either one of these cases directed or even permitted the court to engage in any sort of balancing test at all. Joe's like, I don't know what case he read, but they don't say that. One, that there was a purported state interest of prosecuting against the accused and the individual's First Amendment rights. He says, what are you talking about, Merchan? No such balancing test is ever permitted under the law. It's not what we do here. And your flawed reasoning seems rooted in an unjustifiable expansion of the phrase. What does this even mean? Fair administration of justice that has no basis in the Constitution or legal precedent at all. They just invented it. Just like protecting our democracy, you know? Okay. SCOTUS cases that were cited by the judge, as well as all of the precedents that engage in a balancing test, they all deal with one group or individual's First Amendment rights versus another individual's constitutional rights to a fair trial, not the government versus the people. Whenever the fair administration of justice is pitted against First Amendment rights, Joe says fairness is always moored to an objective of protecting the rights of the accused. So the administration of justice is to protect the Trump team, not the court, not the judge, not the prosecutor. They already have the government, okay? They keep acting like Trump is this big bag boogeyman who's more powerful than the whole DOJ or New York City, I guess. If he says something, we're all gonna die. Are you kidding? Trump posts a truth and there's gonna be like the purge happening on the streets. Not only does the government have unlimited money, they have unlimited power, they have unlimited resources in terms of people and buildings and all things. They have everything in their favor, plus the power of the microphone, the power to prosecute, the power to imprison. They have it all. Now they're saying, you can't talk bad about us too. What? That's the only thing we have is our speech. That's why it's the First Amendment. So they just expand this fair administration of justice. What are you talking about? In this context, it's designed to protect an individual's right to due process. And every time the court is engaged in this analysis, it was in recognition of a clash between the amendments, the first, the sixth, the 14th, and the first. Fair administration of justice is never used as a basis to protect the state. There's no constitutional amendment designed to protect the state from the accused, unless it's Trump, because he's, so dangerous. Now, in Landmark, Joe says the state had passed a law that made it a crime to divulge information about Judicial Review Commission. The basis for the law was that if you disclose, then it might be dangerous to the people who are being investigated, who were the accused, right? Okay, we're investigating judges. Well, we can't tell you who we're investigating. Why? Well, because they've only been accused. They haven't been convicted of anything, and we want to protect their rights. The state said, well, we have interest in the fair administration of justice. We want to protect the accused, not the government. But guess what? The Landmark court concluded that First Amendment rights triumph, okay? So even if you're trying to protect the accused, you still lose because we have a right to see that stuff. Now, similarly, Shepard was expressly decided based on the recognition of the accused's rights to due process, reviewing the activities of a criminal trial where a voracious media married their virulent speculation about the guilt of the accused. This guy's guilty or all over the place, kind of like what's happening here. The continual chaotic conduct in out of courtroom activities affecting the defendant. The court took no steps to control the chaos. The court found that the rights of the accused had been unfairly impacted by the free exercise of the First First Amendment rights. Now, the court left no room for the confusion. They said fair administration of justice may trump unfettered rights of free press only when rooted in constitutional rights of the accused. They expressly said this. We've concluded that Shepard did not receive a fair trial, consistent with the due process clause of the 14th Amendment, and we reversed the judgment because the media was so bad. But the most pivotal failure of Mercan's analysis was to recognize this, the clash of the constitutional rights to free speech that necessitated the balancing test in Landmark. What was the danger of what was said against the need for free expression? But the state trying to prosecute an individual, the state doesn't have constitutional rights. And so under Landmark, a prosecutor seeking to imprison someone is never entitled to the opportunity of persuading the court to enter a balancing test. Landmark stands for principles that are the opposite. The very objective of our freedom of speech and of the press is to call out corruption and to keep the courts in check. The First Amendment is purposefully designed to enable political speech, as they said in Landmark. Whatever differences may exist about the interpretations of the First, there is practically universal agreement that a major purpose of the First was to protect the discussion, the free discussion of governmental affairs. That's the point. So they said there was a First Amendment right to attack both the court and those who work for the court. They say the law gives judges as persons or courts as institutions no greater immunity from criticism. The operations of the court and the judicial conduct of the judges are a matter of utmost public concern. So we're not limiting you, gagging you from speaking about our investigations. Now, by distinguishing the operations of the court as separate from judicial conduct of the court, SCOTUS, the Supreme Court, made evident that it was not merely the judge himself who may and should be scrutinized, but also the clerks and the court. And so Landmark, Joe says, the decision that Judge Mercan literally relied on, it directly invalidates his order. Judge Mercan said this order is justified by Landmark. Joe says it literally says the opposite. Okay, you're saying something different than what the case says. So Landmark then directly invalidates sections B1 of your order, which apparently purports to insulate counsel and members of the court staff from criticism levied by Trump. He's literally allowed to criticize you. And moreover, whether one agrees with Trump or not, or his criticisms, it's inarguable that the overwhelming majority of his posts carry an overt political message, meaning their political speech protected accordingly. Now, that is precisely the terrain of free speech and of the press that Landmark sought to insulate. This court, Mercan, cherry-picked a handful of statements to reach its conclusion while thoroughly ignoring all sentences immediately preceding or following a favored passage. Now, however, reliance on Landmark as a legal foundation for silencing the accused because of legal corruption that he's complaining about requires spinning that decision on its head until it's upside down, until up is down is northwest, and we're living in Crazyville. It's thoroughly flawed, and it should be overturned by this court. Amazing work from Joe Neerman, Good Logic. His channel is linked down in the description below. He continues with a second argument. Joe writes, unlike those cases, this case also involves prior restraint of free speech. Those were after. Now, the Supreme Court is loath to ever validate a prior restraint on the speech. Any prior restraint on expression comes with a heavy presumption against its constitutional validity. Now, if there is a heavy presumption against a valid gag order, how much more so would it be when an individual is being restrained? He happens to be the leading candidate for the presidency, and we're in the middle of a campaign scheduled in 7 months. Now, it's unfathomable, says Joe, that the litany of Supreme Court decisions that repeat their disdain for gag orders would ever grant license to restrain Trump's speech unless Trump's statements were established to be the cause of a grave harm that could not be averted by any less serious measures. And so thus, if we allow Mercan to use this so-called balancing test, it's going to cause harm by issuing a restraint on free speech that's a prior restraint in opposition to what the courts say is appropriate. Now, Mercan actually quoted Landmark. He wrote this in his order. He said, properly applied, the test requires the court to make its own inquiry into the imminence and magnitude of the danger said to flow from the utterance, and then to balance the character of evil against the likelihood and the need for free and unfettered speech. They're saying the nature of Mercan's inquiry was to review documents filed by Bragg. However, that review is not sufficient to warrant the infringement upon Trump's rights. Bragg's motion also set forth a correlative link between the danger and the utterance and didn't establish a causative link. So Trump's speeches, statements, there's no showing that he actually caused any harm. Specifically, the motion alleges an increase in frequency of threatening, or racist, or other unjustifiable communications. Now, in no way does an increase in frequency say that Trump did it. Rather, it seems equally, if not more likely, that the indictment itself, the extensive media media coverage of the indictment. Maybe all the whack jobs on MSNBC caused a reaction from what Joe says are the craziest of crazies. Now, Good Logic is in no way excusing any of these statements. A lot of it is reprehensible and abhorrent. Those actions are indefensible, and any statements like that do merit public scorn. But as gross as these communications might be, their increased frequency was predictable. Okay, the case is getting closer to trial, Alvin. Like trial scheduled a month from now. Clearly, it's going to get more heated as this gets closer to trial. We could also similarly predict that in a hypothetical scenario where Andrew Bailey indicts Barack Obama, that Bailey would be on the receiving end of innumerable bad no-no messages. But there's too many unhinged people at the ends of both sides of the aisle to make that a justification for banning speech. So the question that was begged by the court was whether the improper communications resulted from Trump. It's well-established law that First Amendment restraint must draw strict scrutiny, the highest standard, and you did not conduct an evidentiary hearing, Judge. Strict scrutiny means we have to really have a good reason before we impose on your fundamental rights with government action. And this judge didn't even hold a hearing, didn't even make factual determinations here, didn't talk about the manner of the restraint, any benefits in the issuing of the restraint, and still today, both the judge and Trump and the rest of the world have no idea if there were certain topics or specific words that seemed to cause an increase in these so-called improper communications. No idea. But rather than conduct a hearing to enable the court to get into this and justify a remedy with a compelling need, the judge just accepted Bragg's claims, and that's it. So an evidentiary hearing would have enabled the judge to adduce which words were problematic and make a determination about how public reaction could have been impacted. But they didn't do that. In lieu of conducting a hearing and properly tailoring, using some good constitutional language here, the prior restraint on Trump's speech, no, he didn't do that. He just issued an order as broad as possible. Joe calls it a fig leaf, saying the orders cannot be constitutional because they lack an evidentiary hearing. So we can't see whether this was narrowly tailored to meet a compelling government interest. Even if Trump's statements were found to have directly caused an increase, there's no evidence that a restraint on future Trump statements could also have an impact. There are countless uncertainties about the need for this gag and the harms that come from silencing Trump. And so the only certainty now is that Trump's First Amendment rights have been infringed. It is submitted that there is a heavy presumption against constitutional validity, and that is crushing to a court order that gags Trump without even having a hearing about whether there's a causative link between Trump's speech and the danger flowing from the said speech. Nothing was shown that it was a compelling need. There was no narrowly tailored order, and so this all must wilt under strict scrutiny analysis. Saying accordingly, even if Mercan's reading of Landmark were not misguided, as it is, the improper application of a balancing test is lethal to the outcome. Failure to conduct an evidentiary hearing means we cannot say that even the constitutional analysis was conducted appropriately. And lastly, Joe Neerman, Good Logic's final argument, his channel is linked down in our description. He says, let's talk about Trump's fundamental rights to a fair trial and how those are being dumped on. First, by quelling Trump's right to speak about anything related to witnesses, they've made it impossible for Trump to have a fair trial, and his due process rights are being violated. And while Trump is the individual facing criminal charges, and none of the witnesses face criminal charges, Mercan has enabled the government witnesses to viciously malign Trump on the eve of trial, and they've stripped away from him any opportunity to respond. This has an obscene impact of allowing witnesses to poison a jury before they walk into a courtroom. And the opportunity for witnesses to malign Trump is not theoretical. It happens all the time. We've talked about it. Stormy Daniels released a 109-minute-long documentary called Stormy. Published that on Peacock. She sure did, didn't she? On March 18th. And she timed that to be released right before the trial started. On March 25th, just a week later. Very convenient. A review of the film's trailer, looks like Joe didn't watch it either, says it makes it irrefutable that Stormy centers around her relationship with Donald Trump and his alleged payments to Daniels that are central to the whole story. It's Stormy's whole claim to fame. She's making money off this thing. And when Trump said, can I please see other evidence that went into the creation of that film? Can I see the B-roll, the other footage that was cut out? Can I see, the emails from the producers? No. Judge said, no, you can't see any of that. In addition to Daniels, in the months leading up to the trial, Trump's former lawyer and prospective witness, Michael Cohen, he's been a regular on CNN. He's on there all the time. MSNBC, hanging out with Jen Psaki. Their go-to source for someone to deliver dirt on Trump. They just put him on the air. Now, multiple times per week, Cohen also hosts a podcast called Mea Culpa. Features a derogatory title about Trump to draw in audiences for virtually every show. For the court's convenience, here's a picture of his titles from Michael Cohen. He makes all of these statements statements, Trump can't respond. Michael Cohen and Donnie Deutsch on Trump's stock disaster and his criminal troubles. Can Trump respond? No, sorry. Forbes Trump analyst and Cohen sound the alarm on Trump's stock scheme. He's getting good views on these. Cohen and Dem candidate turn the tables on Trump and MAGA. Lev Parnas tells Cohen more secrets from inside Trump's schemes. Okay, list goes on and on. The guy has a whole career off bashing Trump, and he's making a lot of money doing it. And so that begs the question about his truthfulness behind these beliefs. Now, the court may take note of the 25 podcasts. They were created in just the past 2 months. He references Trump by name derogatorily. He runs for approximately 1 hour long each episode. He has hundreds of thousands of views on YouTube alone. The liberals love this guy. They're like, Michael Cohen, he's my favorite. They go over to each other's, houses for their, did you catch the latest Cohen? Oh, it was so good. He talked about Trump again. I know, my favorite. Cohen's Mea Culpa also airs on Apple, Spotify, Google, iHeart, everywhere. It's difficult, if not possible, to quantify the full extent of his reach through his continual assault for profit gossip about his former client. It is noteworthy that the court never saw fit to silence Cohen or to even urge him to remain silent despite his status as an anticipated witness against Trump, or, the questionable ethics of a former attorney talking about their former client because Cohen got disbarred. Petitioners are not implying, good logic, that either Daniels or Cohen should be restrained in their speech. That's not the point, says Joe. However, the notion that neither of those expected witnesses are facing imprisonment, but they're permitted to ceaselessly peddle noxious perspectives of the defendant to their extensive audiences underscores the unconscionable unfairness of Trump being gagged. Now, while it's true that most criminal defense attorneys would likely urge Trump or any criminal defendant to be quiet and avoid discussing these people, good logic says that these perspectives does not merit significance in calculating the court's propriety of making a gag. And that's true. And I think that most people, criminal defense attorneys, would also say, well, this is a unique situation. This guy's running for president, and part of the defense is to win, to fix the corrupt system. Like, it's not a legitimate prosecution, right? If Trump wins, it's going to be a correction. It's going to correct the entire DOJ and, be a return to form of justice. You can't just defend the single battle. You've got to win the whole thing, which means winning the presidency. So he has to prioritize these things. But the point remains. Now, fundamental fairness and constitutional due process dictates the court has no right to prevent Trump from responding to witness vitriol if he's so inclined. And finally, good logic urges the court to recognize the public policy and grant this. We are sadly, says Joe, living in a time where political divisions are dividing the country in ways few of us can remember. Says it's easy to mistakenly think that muting one whose words can be deemed grating is downright abusive is a healthy means of calming a storm, but that is a grave error. Says kindly recognize the wisdom of the landmark court and their counsel about the inevitable backlash from stripping away our fundamental freedoms of speech and the press. Says unenforced silence, quoting from Landmark, however limited, solely in the name of preserving the dignity of the bench, would probably engender resentment, suspicion, and contempt much more than it would enhance respect. Kind of like, legal interpretation of the Streisand effect. When you try to silence something, everybody listens to it. So good logic wraps this up. He says, okay, here's the deal. We are entitled to a restraining order and an injunction. As detailed, precedent says that prior restraints on free speech, like the Trump gag, are faced with a heavy presumption of being constitutionally invalid. And so we have a high chance of likelihood. We also know that Merchan relied on flawed analysis of Landmark and Shepard, and the freedom of the press is offended by the gag order that he issued. If a prior restraint is ever available, it's not going to be when there's a political campaign and political speech. And if they're going to do it, you better have an evidentiary hearing to make a determination about whether this is appropriate. The court's failure to conduct an evidentiary hearing leaves Merchan's findings of fact way too hollow to justify ripping away someone's free speech right. Now, the respondents, Merchan's fleeting review was a misapplication of the law, and it creates fundamental unfairness to Trump, muzzling him, turning him into a public punching bag when public perception may mean the difference between conviction and acquittal. And on that basis alone, Trump must be unchained from these gags so that he can speak in the arena of American ideas. If the petitioner's application is denied, we will suffer irreparable harm, and the balancing of the equities favors the relief that we're requesting. An unproven theory that Trump's statements may or may not relate to improper conduct by unknown third parties, the dangerous speech, outweigh three definitive wrongs that necessarily resulted from judge's orders. One, you stripped him on the eve of trial of his most fundamental right of free speech. speech, and they did that intentionally. And they incapacitated freedom of the press for petitioners and countless others who want to listen to Trump and his statements when he goes through trial. And lastly, and this one's for us, my friends, rob every American the opportunity to weigh the words and the thoughts of the man that they will reject or they will elect in our impending presidential election. Saying the urgency is critical here. Every minute that Trump's First Amendment rights are obviated and that good logics and all American civil rights are ignored, every minute evaporates and it can never be recaptured. With the looming New York trial scheduled to commence in any day now, we need to move now with uncommon exigency. Now, often our initial reaction is correct, but we outsmart ourselves. The very first words from Judge Merchan are right. He said that such restraints are the most serious and the least intolerable on First Amendment rights. We are at a precipice that is unique in American history. Good logic tells us a former and potential future president of the United States is about to engage in his own criminal defense. Kindly do not allow history to forever record that these unique proceedings were tainted by the foul stain of blatant disregard for Trump's First Amendment rights, as well as First Amendment rights of us, every American. And therefore, good logic is therefore respectfully requesting that Trump's gag be reversed and that this court grant relief as appropriate. Signed by Joe Neerman, Good Logic, journalist, YouTuber, content creator, rumbler, localer, and all the things, a member of the press in New York, and as far as I know, the only member of the press in the whole stinking country who filed anything of the sort, who wanted to get Trump and his free speech rights back on track so that he could participate in the election. Shout out to Good Logic, Joe Neerman. On a good motion, we'll be continuing to pull for him so that we have access to free speech in America from a candidate who is running and leading in many of the polls. We'll be here continuing to cover this case, and Good Logic's channels are linked down in the description below. His YouTube is, so make sure you go follow him on that one and send him our love on a great filing, getting into the mix out there in New York. Very good to see it, and we'll be supporting him. So thanks for supporting him, supporting us, my friends. Don't forget to like this video and subscribe wherever it is you're watching it. We've also got some of our links down in the description below. Our locals community, watchingthewatchers.locals.com. We have extra after parties as soon as the shows are here. We do live streams in the morning, and we have an amazing community. We'd love to have you join us. We'll see you over there and back here on the next one.